Hi, my name is Damon Parker. I am a licensed immigration advisor practicing at Swift Visa Limited in Auckland. The topic I'm covering today is visa reconsiderations and unlawful status. The main points that I intend to cover today are options for migrants that have recently had a visa declined or have become unlawful. I won't cover humanitarian appeals, which may be an option for some, as this was covered by the previous speaker. I'll be covering the changes to interim visas briefly, lodging reconsiderations, Section 61 applications, and complaints through INZ's complaints and feedback process. Interim visas are valid for 6 months from the date that they are granted. Immigration New Zealand made a change to interim visa instructions in August 2018, which provides a 21-day extension to an interim visa from the date an application is declined or withdrawn, so long as their interim visa is still valid. This gives the applicant the chance to leave New Zealand while still holding a valid visa, and also provides an opportunity for the applicant to lodge a reconsideration. While the changes are a good step in the right direction, interim visas are still not entirely fit for purpose. There are still scenarios that will cause someone to become unlawful if their application is declined, so it's important for advocates to have a good understanding of the new interim visa instructions. Reconsiderations. What is the procedure for lodging a reconsideration? The right of reconsideration is outlined at E7.35.1 of the Operational Manual, Section 185 of the Immigration Act, and Section 14 of the Immigration, Visa Entry Permission and Related Matters Regulation 2010. The instructions outlined at E7.35.1J also provides that INZ may consider a reconsideration request for an offshore declined application if new and compelling information is promptly provided. The requirements for lodging a reconsideration are reasonably straightforward. The client must currently hold a valid visa and be in New Zealand. An interim visa meets this criteria. A reconsideration must be made within 14 days of the date the applicant was notified of the decision. The original decision to decline must not have been made by the Minister of Immigration. Though not specifically stated, INZ requires reconsiderations to be made in paper form. INZ does not provide any electronic method for submitting reconsiderations. This is important as it will affect your planning when you are preparing the reconsideration. Immigration advisors will need to be identified on the application form or provide an INZ 1160. Things to be aware of when submitting a reconsideration request. It's important to take a systematic approach when submitting a reconsideration request. Advocates need to pay special attention to the reasons for a decline decision and systematically address them. It is necessary to review all correspondence from INZ and carefully outline what the issues are in your own words. This should form the basis of your approach. It may be necessary to review the correspondence several times to make sure you haven't missed any concerns. You also need to be cognizant that INZ's correspondence may not tell the whole story. There may also be additional concerns recorded on the client's file that are unavailable to you. It is likely that you won't be able to get urgent disclosure before you need to lodge the reconsideration, so it is also helpful to review the applications and submissions made to try and determine where else the application may have been deficient. One issue that we've noticed recently is that advisors are not adequately addressing concerns in the initial application, and they're making the same mistake during the reconsideration and trying to argue the merits of the application for a client that simply hasn't demonstrated that they meet immigration instructions. A reconsideration request is still an application. If you're able to address all the reasons for the decline decision, INZ is required to put new concerns to the applicant before making a decision. It's not a good idea to argue the merits of a decision or that a decision was incorrect in a reconsideration request. If you do, it is highly likely that INZ will come to the same conclusion and decline your client's application. You will probably have a better chance of success providing additional information. Now moving on to Section 61. Section 61 is one of the least prescriptive sections of the Act. What is the procedure for lodging a Section 61 request? Instructions related to requests for visas under Section 61 are outlined at A23 of the Operational Manual. Immigration legislation and instructions do not provide lodgement requirements for requests under Section 61. Requests can be made by paper or email, with or without a form. There's no right for a person unlawfully in New Zealand to apply for a visa. Generally, when making a request for a visa under Section 61, we do so via email to Section 61 or s61@mb.govt.nz. We do not ordinarily provide a form, unless we have one that's already been prepared. For example, if a client has lodged their application out of time and is requesting our assistance. There are 3 possible outcomes for a Section 61 request, which will be outlined in the decision letter. Refuse to consider. INZ has not considered the request at all. INZ considered the request and refused to grant a visa. INZ considered the request and granted a visa. INZ must record reasons for any decision made under Section 61, but is not obliged to give those reasons to the applicant. Immigration instructions at A2310C state that an officer may, at their discretion, provide reasons, but if no reasons are being provided, they must state that Section 11 applies. Things to be aware of for Section 61 requests. Always recommend that the client leave New Zealand and apply outside New Zealand for a visa. The grant of a visa under Section 61 is discretionary, whereas an application offshore needs to be assessed by Immigration New Zealand. Make sure to advise your client of their chances. Whether an application is futile is subjective, and even if the chance is small doesn't meet the threshold of being futile or grossly unfounded. Nevertheless, it would be prudent for advisors to warn advisors if there is a low chance of success. Get the client's full file from immigration. The only exception is if the client has a straightforward immigration history and has only very recently become unlawful. If there are any doubts about your client's immigration history, get the client's file from immigration. What is a special case? I've got some case studies here. We've been told by immigration that they consider why a person can't leave and apply offshore. While it should be at the forefront of your mind, it isn't always a consideration for immigration. Whether a person's case is special varies a great deal. Some visas are granted to people whose circumstances seem to be perfectly ordinary. Does your client have New Zealand citizen children? It might be the case that you have a client who has overstayed for a very long time and has NZ citizen children. In one case, INZ granted a one-day visa under Section 61 so that the applicant's circumstances could be tested in a humanitarian appeal. Does your client have a New Zealand citizen partner or a temporary partner? Generally, these types of applications don't represent a special case, unless you can show a compelling reason for why the person is unable to leave the country. We've had some success with people leaving and applying for these types of visas from offshore. If you have a student overstayer, you may have a student who's forgotten to renew their visa. Provided the student makes an application soon after their visa expires, immigration is generally willing to issue visas to students under Section 61. However, there is a major caveat. They must meet student visa instructions in terms of attendance and academic progress. It's also important that the student not have any other issues. One of our clients was refused a visa under Section 61 because they were stopped, fined, and turned around at the border many years prior for not declaring cigarettes. This is despite the applicant otherwise meeting student visa instructions and immigration granting a later visa and accepting that the non-declaration was a genuine misunderstanding and issuing the client a visa to return to New Zealand. We were able to get reasons for the Section 61 decline because INZ did not redact the reasons when we requested the file. You may have a client who is the guardian of a student visa holder. On occasions, we've had applicants who failed to satisfy instructions for the grant of a work visa and had a child studying in New Zealand as an international student. INZ didn't consider whether to grant a visa as an exception to instructions, but when we submitted a Section 61 request, immigration granted a visa. Immigration will sometimes grant different types of visa to these people, for example a visitor visa, so that they can test their eligibility for a work visa again. Now we move on to Immigration New Zealand's complaints and feedback process. The feedback process provides clients with an avenue to seek resolution of a complaint relating to the service they received from Immigration New Zealand. The CFP is not an avenue to seek a review of a declined visa application, an invitation to apply for residence, or a request for a visa made under Section 61 of the Immigration Act. Full information about the CFP can be found on the INZ website Complaints and Feedback Process page. The operational manual provides some information at A9. INZ's expectation is that clients will access the CFP to seek resolution of a complaint before approaching the Office of the Ombudsman. INZ endeavours to respond to all complaints within 25 working days of receipt. Where INZ determines that it erred in the provision of a service to a client, a remedy, if appropriate, will be provided in response. So what's the procedure for lodging a complaint? There is no prescribed manner to submit a complaint. Immigration has an online portal for making complaints. You can also submit complaints via email, and hard copies can be sent to the Central Feedback Team in Wellington. Advocates should seriously consider complaints where INZ has erred in its decision. In some cases, it may be more appropriate to use the CFP instead of submitting a reconsideration or Section 61 request. In cases where a procedural mistake has resulted in an unfair decision, INZ will roll back the application for reassessment. Complaints must be made within 6 months of the decision for INZ to consider it. INZ may consider a complaint outside this period in exceptional circumstances. INZ will only consider procedural errors and will only consider merits where the decision exhibits significant unfairness to the applicant. When preparing a complaint, advocates should assume the person reviewing the complaint knows nothing, because they don't. Rather than let them seek out the information, provide everything you want them to review, wherever possible, including AMS notes, letters of concern, the decline letter, relevant submissions and evidence. In some cases, it might not be practical to provide this information. For example, if you have lengthy recordings of interviews, it's not exactly easy to send these via email. Don't submit new information. If you have new information, submit a reconsideration request. In your submission, you should explain why the errors resulted in unfairness to your client, and you should bolster your submission with IPT case law where possible. So what is a procedural error? INZ doesn't provide a definition for what it considers a procedural error. However, there is a wealth of IPT cases where the IPT has referred an application back for being procedurally unfair. You can use these when complaining about temporary decisions only. Complaining about residence applications will get you a standardized response that the applicant should lodge an appeal. Now we have some case studies where the process has failed and we've managed to get immigration to reverse the decision and reconsider. The first case study I'll be looking at is the character waiver assessment. The client had a drunk driving conviction, and in the character waiver assessment, immigration considered property damage during the drunk driving incident, and also weighed the applicant's course of study against him, as it wasn't on a skill shortage list, when assessing whether to grant a character waiver. The applicant had damaged a car in an unrelated car accident, and had submitted receipts for the damages when he submitted his student visa application. Unfortunately, immigration didn't notice that this had nothing to do with his drunk driving conviction. Also, the fact that he was studying accountancy, it wasn't particularly clear how this counted against him. INZ agreed that the character waiver assessment was flawed and rolled back the decision. In one case, the further submissions by a specialist were not considered. An applicant was receiving treatment for a condition. As a consequence of receiving treatment, INZ determined that they did not have an acceptable standard of health. During the application process, the applicant produced a medical opinion that they should not have been receiving treatment and had not met the criteria for treatment. In another case, the applicant asked for a shorter duration of visa. INZ determined that the applicant was not ASH for a shorter visa without seeking comment from a medical assessor. During an application for a 2-year post-study work visa, the medical assessor deemed the applicant as not ASH, as he had signs of significant hardening of the liver. It was likely that the applicant would incur significant costs on NZ's health system. When the applicant requested a 3-month visitor visa as an exception to instructions, so that he could deal with his affairs to leave New Zealand, the case officer declined his application. INZ agreed that this was procedurally unfair in terms of health instructions, because the MA must consider whether the applicant is likely to impose costs for the duration of their stay, and also when considering whether to grant a visa as an exception to instructions, as the case officer is required to consider all the circumstances. In my next scenario, a student provided sponsorship with their original offshore visa application. When applying for a further student visa onshore, they tried to provide a different sponsor. INZ is not able to accept a different sponsor. Their student visa was declined. I submitted that the decision was procedurally flawed because INZ was applying immigration instructions that don't exist. One of the concerns outlined was that the applicant provided no evidence that they had received funds from their sponsor. This is not required by instructions. INZ applied the wrong immigration instructions. Case officer referred to generic temporary instructions instead of student visa instructions. And INZ also required the applicant to hold funds in New Zealand despite them providing a sponsorship form. And INZ didn't properly explain their concerns. INZ raised character concerns because the applicant didn't complete an optional section of the form. INZ didn't clearly state that a different sponsor could not be accepted. INZ considered that the applicant was not bona fide, but didn't give reasons other than the applicant had no compelling reasons to change their course of study. Inconsistent decision-making. An applicant applying for a student visa was declined for breaching the conditions of their visa. The applicant had previously owned a business in New Zealand as a failed entrepreneur applicant. Their application was declined as INZ considered that they had been working in breach of their visa conditions. The client's previous applications for a student visa had been successful, and their circumstances had not materially changed since the previous decisions. In another scenario, immigration wasn't following their own internal advice. An applicant applying for a work visa was issued a letter of concern that their rate of pay was below market rate. INZ relied on only one source to determine market rate, contrary to advice to INZ staff, which requires consideration of multiple sources. INZ also raised new concerns when declining the application by providing a new market rate in the decline letter. The applicant wasn't given a chance to respond to this new information. I hope this gives you a good overview of some of the options available to migrants in difficult situations. In summary, if you have new information or could better address concerns in a declined decision, a reconsideration is a good option. Your client may have special circumstances which they may be able to use to gain a visa under Section 61. Finally, if INZ has made a critical mistake when assessing an application, the complaints process would be an appropriate avenue to seek a remedy. So that's the end of my presentation. I still have quite a bit of time left, though. I was asked to prepare a 45-minute presentation, and I'm a little bit more used to preparing a 20 to 30-minute presentation. So I thought I'd just briefly discuss some of the Section 61 and complaints that we've handled, because I think they're probably the most interesting ones. So under Section 61, we've had a reasonable amount of success helping students get visas after they've inadvertently overstayed their visas. Most of the time it's not an issue as long as they're good students, but occasionally we have the odd case like the one where the applicant hadn't declared cigarettes, and that was really unfortunate because immigration, well, we actually argued that particular visa as well. So when the person wanted to return to New Zealand to study, we actually argued for the visa despite the fact that she'd been turned around at the border, and we had a pretty extensive record that immigration had quite carefully considered that and accepted that she just made a genuine mistake by not declaring the cigarettes. And what was really interesting was that she particularly commented that when she was entering New Zealand on an earlier occasion, a customs officer told her that that's fine, like that's fine when she declared cigarettes, and she misunderstood that to mean that she didn't have to declare those cigarettes. So it was, and immigration accepted that that was a genuine misunderstanding. So it was quite surprising to see the Section 61 consideration notes, which, by the way, that's the only time we've ever received them. But they quite clearly mentioned that she'd been turned around at the border, and it was quite clear that that fact alone was the reason why they declined a Section 61, because they didn't give any other reasons. She was a very good student. And then when she left and applied offshore, we continued to encounter problems, and we actually had to utilize the complaints and feedback process again to get her a visa when she was applying offshore. Because again, immigration had made a number of mistakes in their assessment of the application, and the manager even refused to acknowledge that mistakes had been made. And it didn't appear that the manager had actually had carefully looked at it, and there was quite a large argument back and forth until finally immigration reassessed, and they even interviewed her, and then finally she got a visa and she's back in New Zealand again. And then the drunk driving one, that was really fascinating, because when we looked at the character waiver assessment, we had the clear table which had the pros and cons and some of the things that they'd considered against the applicant, like his chosen course of study. It just didn't make any sense. Like, why would that count against him at all? It was quite bizarre. And they had they'd taken into consideration the drunk driving conviction, and they said that it was serious, but they actually hadn't considered the seriousness of the drunk driving conviction. Like, they didn't consider the circumstances, the sentence that he received, and from the brief that the client gave me and from the police report itself, he'd driven a couple of 100 meters and was pulled over, and actually he could have walked home. It was really quite just unfortunate that he didn't make that choice. He decided that he would drive his car 200 meters rather than just walk that distance. And immigration agreed that that was an utterly flawed assessment, and we got him a visa when they reassessed it. And then the other one that I thought was quite fascinating was the ex-entrepreneur applicant, because she still owned the business that she had used to apply under entrepreneur category unsuccessfully, but she had arranged for somebody else to run that business and had applied for a student visa. She'd been granted a couple of student visas subsequently, and they did actually raise concerns in the earlier applications that she was working in self-employment, which is not allowed by student visa conditions. But in the earliest student visa application, immigration came to the conclusion that she was not working in self-employment. And then in the next application, there were no concerns raised. And then in the third application, in which she was declined, immigration raised the exact same concerns again, but didn't actually produce any new information to show that they'd recently become aware that she'd been working in self-employment. They'd relied on very old information, and immigration agreed that that was inconsistent decision-making. So there's some room for complaints if you have clients in your office and you're looking at decisions. But at the same time, we have also looked at decisions where we found no fault at all. And we've provided reports reporting back to clients saying that, look, there really is no issue here, so we can't complain, and you're unlawful, so you should leave. And then in those situations, it is definitely better to apply offshore. We've had student visa applicants declined for not progressing well enough or not attending, and then they've had a partner in New Zealand, so they're eligible for a partnership-based visa, and we've recommended that they leave and apply offshore, and that's proved very successful. So that's all I really have to say. Unfortunately, I wasn't able to attend in person today, so I can't take any questions. But if you have any questions about my presentation, you can email me. You can find my details on the IAA website or swiftvisa.co.nz. That's all I have today. Thank you.